This is a continuance of the special permit application from Toledo Development Group to obtain a special permit and or variance of the provisions of the applicable sections of the zoning bylaws of the town of Sunderland for the purposes of constructing a 9,100 square foot retail building with associated site improvements on the premises of Amherst Road 116, tax map number 9, plot number 44 in the town of Sunderland, all in accordance with provisions of Chapter 48 of the Massachusetts General Laws. So, this is the 9th hearing in this series, and the main purpose of this, and using the agenda, is that we had asked and we contracted a consultant to do a peer review of the storm water and drainage report. That's going to be the main focus of this hearing. And a report was delivered, and I forwarded it to the board and forwarded it to the applicants. And what I'd like to do, and I got an agenda and I hope we can stick to it, is to ask the consultant to give a report, an overview or highlights, or however you want to approach the your report.
Thank you, Steve.
So, and you are Bucky Sparkle?
Yes.
From you're the Zengineer?
Zengineer is my business name, yep, ZBA, Bucky Sparkle. Where would you like me here? Just standing is fine, or? Okay.
Just so we
It's
can
up in
all
a
hear
podium.
you.
Okay.
Maybe introduce yourself again.
My name is Bucky Sparkle. I'm a civil engineer. I've been doing civil and environmental engineering for over 30 years. I've done quite a bit of municipal work, as well as commercial development, do a lot of stormwater, wetlands. This kind of development is right up my alley. I have a lot of experience in it. I do have a few notes here. So, of course, I did receive the full submittal package, which was dated back in August for the most part, for the plans, a stormwater report, as well as a letter from Attorney Michael Pill and Bowman's traffic impact study, which were June dated documents. I produced just a couple of weeks ago a 12-page letter that covered in detail the plans regarding stormwater management in the report, as well as looked at the plans in terms of the local bylaw and overlays. And that the letter was very detailed, and I was expecting tonight to be talking quite a bit about that. However, this afternoon I also received a rebuttal to the letter, and I'll get into that. So it just took some time this afternoon, but saves us all a little time this evening. I also did receive a letter that was written by Gabrielle, also known as Ellie Kruth, regarding the Watershed Protection District and the IWPA that is associated with the wells at Cliffside Apartments. Regarding that memo from Ms. Kurth?
Yes.
Kurth, thank you. I provided an email.
Mr. Sparkle, just before you get into this, I would like to have you focus only on your report to start.
Okay.
And I know that you received a report on your report from the applicants.
Yes.
I'd like to save that for later, but following the agenda I set forth, I'm trying not to get this to be a point-by-point, counterpoint, rebuttal, and back and forth, but I'll just have you do your report, your highlights of your report, and then the board can ask you some questions, and then we'll go from there for the agenda.
Sure. In many ways, the highlights of my report have been now rendered moot. So the reason for that is I had 83 points in my letter. 78 of them have been satisfactorily addressed by RLA, which leaves 5 points, most of which are typos. There are very, very few things of technical merit to discuss. And there's only really one thing I want to see changed, and it is one of the most minor things I have seen on a site plan in a very long time. The reality is, as far as the site plan and stormwater report go prepared by humans, there were some glitches, but the design itself was really quite sound. It covered all the stormwater requirements, generally covered the bylaw. There were some minor things strewn throughout it. Like I said, 12 pages, 83 points, but very little of those changes would take more than a few keystrokes to update. So RLA has provided a new set of plans that I had a chance to not deeply go into. I didn't re-review the plans. I just went relative to my 83 points. And like I said, 78 of them are greenlit. They're all fine at this point. And the only thing that really sticks out at this point is I would like to see a small portion of the parking lot to be slightly steeper. It's very flat. I don't know why it's quite so flat. I know there's a good reason for that. And I have some icing concerns. And considering that this is outside of, but not far from, a well IWPA, an area where you want to minimize salt. If we have an ice area, that usually gets more salt. So let's try and keep that from happening and remove any motivation to apply excessive salt to the parking lot. But out of the 12 pages, there's almost nothing to talk about at this point. I also did review the revised letter from the traffic engineer Bowman, because there were a few things that they had a plan set that was not as current as the one I reviewed. There were some discrepancies. They identified those and indicated that their review doesn't change, which doesn't surprise me, considering what they were, but I wanted to make sure that they did, A, have the same plan that I was looking at, and B, that their numbers didn't change with the minor changes that I noticed. I will have, a few things to say back to RLA, really just some typos and a couple of minor CAD errors that point to nothing. I mean, just nothing to discuss in a public hearing. Other than literally reviewing the 12 pages, I'm not sure that I have much to offer the board at this point.
Well, I know that we asked for a peer review because to me, I was somewhat intimidated by the stormwater and drainage report. Not being a civil engineer, I didn't know what, I had some concerns that we really didn't understand what was there, and stormwater and drainage is pretty important. One of the criteria we look at is the quality of the natural environment, and as brought to our attention by Ellie Kurth, there were drinking wells in the vicinity, and there's concern about runoff when they're going to be adding material to this site, and we're going to make sure that the first of all, that there's no drainage off-site, and that the design of the subsurface filtration system was adequate. I had some questions, and I don't know. Already we're going a little bit off script, but that's happened just about to every one of our hearings, is that somehow goes off script. But we'll work through and we'll end up at the same place at the end. I had some questions about some of the data that was taken with the some of the 12 test holes that were drilled. There was water struck at on 6 of them, and the depth of the water was noted. I'm just curious, the ones that were dry, or how deep did you go? Or how deep were the holes?
Yeah,
Well,
I can certainly answer it, absolutely. I'll stand up. Philippe Cravo, Levesque Associates. Typically, when we do our stormwater designs, in order to establish the groundwater elevation, we get on site with a preliminary concept of the site plan, and we dig what we call test pits. And those test pits are performed by a licensed soil evaluator, licensed through the state of Massachusetts. And what they're looking at is usually typically they're on site with an excavator or some type of backhoe machine. They excavate a test pit where someone actually goes down in there about 4 to 5 feet, and they look at the soil profile within the test pit, and they use their background and what they've been taught to look for what's called redoxamorphic features, and that's what establishes what we call estimated seasonal high groundwater. So it's not necessarily water standing in the hole or water leaking off the face of the test pit, but just redox features, which are essentially iron deposits where when water goes up and travels up and down the soil profile, it leaves a staining within the soil of an iron oxide layer called redox features. And we use that to establish what we call estimated seasonal high groundwater. So it's not always water, but it is a line that we use. From that line, there's a minimum separation distance to the bottom of, for example, a subsurface infiltration basin. I'm sorry, I'm getting kind of traveling off point, but typically we dig test pits down to about 10 feet or groundwater, which is what we did on site.
So, I mean, so the holes that were dry, I mean, you dug out 10 feet.
Yes.
And you did not strike any water there.
Correct.
We've dealt with a spec that's called mean max groundwater table. The board we've had special permits for gravel pits, and to try to say how far down they can dig and remove gravel. We'll give a number or not within 10 feet of the groundwater mean max groundwater table. Do you have any data, or is it in the storm report of where that is, or is that a useful?
So I think, when typically, like gravel pits are a very specific type of situation where you're usually working in a sand or gravel bank, and water is typically very deep, so you're working with soil borings. So it's essentially an auger that drills straight down for, however 100, couple hundred, however deep it needs to go. Then they establish groundwater within that boring. What we do typically in a site development situation like this is we get out on site, excavate the test pits within the site, within the leach field area, and we did a number, I believe 12 across the property here, and they were all very consistent, and established the seasonal high groundwater locally on site in the location that we're proposing infiltration.
Is that seasonal ground, pipe for groundwater? Was that data put into the report?
Yes.
Okay. I didn't see it, but this all leads to a question about the subsurface filtration system.
Yes.
About how high is it above groundwater or above this?
Fortunately, in this situation, we're about 7 feet above the groundwater. 7
Do you agree
yeah.
with that assessment that they're,
Yes, it is a significant offset. I don't recall the exact number, but it was by far more than the minimum. So 7 feet sounds about right. Most of the groundwater was encountered, I think the shallowest was like 74 inches down, so just over 6 feet. But most of them were 100 inches, 120 inches. And those tests were depths from existing grades, and much of the site is built on fill. So effectively, you're building even higher than those logs. So even if they didn't fill, they would have adequate offset to the groundwater for their stormwater management systems.
board members have any questions?
Just a general question. It seems that all the points that you had made in your report were small changes that needed to be made and addressed by the applicant.
Yeah, I tried to be thorough.
And you're saying now that almost all of those have been answered?
Yes.
So our peer review, you, with those corrections, you find there not any areas of major concern?
There were never any areas of major
Okay.
concern. Even with the original 83 points, there wasn't anything that I call a showstopper, where the designer would have a challenge to address my concern. They had some questions, they answered them, made some minor changes. I'm happy with that. So they were very responsive and just in time.
And, for the record, Nina Fazio did submit all new revised drawings like we had seen before, and we have some, we have the full-size drawings here, just like we had initially. So we got all new reports and plans based on the ones that were revised. So, so much for the agenda. I don't know, where I was going to ask was at the applicant response, and that's why I asked for you to bring, 10 copies of your report, and I don't know if there's, I don't know if you have any further, like, I wasn't planning to go point by point, but it looks like I
Steve, you want to hand it?
yeah.
You need this one, you take this one.
What's that?
I said you need another copy, I have it here.
Well, you made a copy of the...
No, I took one off the file, so if you need an additional one, I can use my electronic copy.
Steve, can we just go through these individually and then point out highlights rather than taking your time to go through each one individually? Some of them are very minor, so I just don't want to get hung up with a lot of time with.
I don't know if there's anyone going through all of these.
Probably.
Just trying to get in on the Zoom, according to that.
If I could, through the chair.
Sure.
Typically, understanding that we submitted this letter, earlier today and haven't had a chance to, thoroughly review the responses to the peer review comments. We understand, typically what we would do is we would come back with a letter from the peer review engineer saying that everything has been addressed. Like these few minor outstanding comments would get all hashed out so that there's 0 outstanding items. And at the next meeting, we would come back with a letter saying, everything has been addressed. I have no further concerns, or however it gets worded. So we understand that obviously we're not looking to have a rush to judgment, understanding that the documents were submitted earlier today. So I just wanted to put that out there.
I have some just general questions on the site now. You're going to be adding a lot of fill to this site. It's going to be
Yes.
raised up. Could you speak to how, how the site is contoured so that there isn't any runoff? So, in general, how much higher is this site going to be versus the surrounding parts of the area?
Yep, I understand the question. So generally, the site is located off of Amherst Road, and if you happen to drive by, you'll notice that the site kind of is in a depression off of where the road elevation is.
Can you just stay on the opposite end, so.
Sure, yeah, I'm going to flip to a page here. This is the grading. Just wanna stand up. So this is the proposed grading. So just to give everyone some sort of perspective, the grades along Amherst Road, say right in front of the proposed curb cut location is 173. It's the proposed grade, from the roadway to the property line will be a slight climb and then grade back onto the site. So within the right-of-way, that will be a vegetated area that will be filled up to be essentially level with the side of the road, with Amherst Road. And then everything from the property line will grade back into the site. Similarly, Clark Mountain Road, where the curb cut is, the grade right outside the curb cut is about 175, and from the property line, it grades back onto the site. So the site, all the impervious area within the site comes back to the site and gets treated through the proposed stormwater management system. So there's no runoff from any of the impervious areas on the property to the adjacent roadways.
Including roof runoff and...
Including roof runoff. So behind the proposed building, there's a surface infiltration basin which will collect the roof runoff and infiltrate the roof runoff in a surface basin there. So I hope that answers your question.
Is it within your professional opinion that this design will achieve its purpose?
Absolutely.
Now, one of the things was noted by Ellie Kurth in that letter that I sent to you, was that there are 3 wells that service Cliffside Apartments that are actually kind of east and north of the site. And could I ask you to comment on that?
Sure.
Because part of one of the radiuses does clip part of this whole parcel. But,
Yeah. So Cliffside Apartments has a public water supply whenever you have a well that supports more than, I think it's 25 people, and other thresholds, and that apartment certainly has more. You end up with a regulated well, and around those you have different protection radii. One is a zone 1, it's very strict, and for this case it's 330 feet, something like that. They also have what is called a zone 2 for some wells, but that takes quite a bit of geotechnical study in a region to establish a well-delineated zone 2. So what most wells will have, and this is the case for the 3 at Cliffside, is an interim wellhead protection area. So it's another radius that is based on flow rate. And that flow rate, I think, generates, they go from a few hundred feet to about a half mile. This one has 990 some feet, I think, as a radius. And that radius, I believe, with the wells are out here, And that radius intersects the property somewhere around here, outside of the development proper, but this lot does continue a little ways here. I'm not quite sure how far. And somewhere before the new impervious area, that IWPA radius intersects. Now, independent wellhead protection area is, it's not a showstopper. If you were in a zone 1, you would have some serious development limitations. In zone 2, it's based on use. What are you doing in that area? Does it have higher potential for pollutants? Are you storing chemicals? Are you an industrial manufacture facility? And in Ellie's letter, she provided a copy of the SWAP, which is something well assessment, I forget what it stands for. Source water, thank you. Assessment per pollution, or do you remember what the P is? It's sort of a report card for the well. And it says, what's going on there and how is it being maintained. And it also references several DEP standards, which I then took a little bit of time and went through, and they have a matrix for use versus risk for wells. And I went through and read through that as well today. And the gist of it is, I have a copy of it, if there's a matrix of use, sort of like a bylaw, like what uses are allowed in what areas, and there are risk assessments for groundwater and for surface water for each use of concern. And you look under the commercial, you look under the industrial uses in the DEP's letter. Retail establishment isn't even a concern of theirs. They do have listed sort of under miscellaneous stormwater management systems. And that does have toward groundwater a low potential for risk. To give you some perspective, a lawn is a moderate potential, a garden is a moderate risk level. So the stormwater management system is a lower risk level than a garden in the IWPA, and they are outside of the IWPA. So my recommendation is, since we don't precisely know the borders, whether we're in or whether we're out, minimizing the salt use is still an excellent idea, just in general for the environment. But I would definitely say that's something that this particular site, being on the cusp of a bedrock-based well, it's a good idea to make sure the salt is not excessively applied. The reason why I want to increase the slope of the parking lot. But a well-maintained stormwater management system with the appropriate best management practices, BMPs, that the DEP supplies, what they count, that is in place. They have good stormwater quality management systems. I think the system is a little oversized. I don't think it has to be that big. It's fairly robust. I don't have any concerns with the particular use or their stormwater management system. Like I said, a garden has more risk than what is being proposed.
As I recall, when, looking at that SWAP report, those wells are fairly deep.
Not particularly deep. They're only a couple hundred feet, maybe not even 200 feet in some cases. So.
Would they be affected by, the groundwater, or if groundwater got?
Yes. In the case of these wells, as I understand from that report, there isn't, a barrier layer between, the surface water and the groundwater. So if there were clay or heavy silts, anything that if there were an oil spill, it soaks into the ground, it moves with the groundwater, but it would then have a barrier between the deep aquifer that is the potable water aquifer. With the geology around here, that does not really exist. It goes right into the bedrock, the groundwater, anything that lands there, which is one reason that in the 300-foot radius to these wells, no salt is allowed to be applied. That is my understanding as a resultant, that cliffside apartments can't apply salt within that area because there is a concern when you are that close. But we are, in this case, 3 times out. And I know that according to that SWAP report, that Cliffside does apply salt to their parking lots in the IWPA, so right up against their own well.
You spoke about a couple of recommendations for conditions. Can you just summarize them?
Yep, I'm gonna have to look those up. But I brought that. Last page. Oh, you can get there. Recommendations, all right. Okay, yes, so while there were a dozen test holes done on site, and the results were very, very consistent, technically, there was not a hole set in the infiltration basin. Technically, you really need one. So the recommendation is that the first thing that happens on that job site is that somebody goes out there and digs a hole to make sure that the soil there is the same as all the soil surrounding it. It's very consistent. The soils map suggests that there isn't going to be a surprise. But surprises happen. So that should absolutely be verified. And even if they find different soils, it just means they would have to change the design. But we'd want to make sure that the design is appropriate for the soil and water conditions. So that's a condition. I recommend them minimizing the application of winter salt, even before I was considering the IWPA. And also, the traffic study was very specific to the use, and of course, if this facility changes from a retail store, whoever comes along afterward really should do another traffic study to make sure that that particular use is appropriate. Usually that kind of bubbles up to the surface in a new permit hearing, but I wanted to make sure that was highlighted. But those are the 3 recommendations I had.
You had mentioned, just probably maybe to both of you, that this filtration system needs some sort of maintenance, or is that normally done? Who's responsible for doing that? And
So as part of the stormwater report that is prepared, one of the requirements is the preparation of a long-term operation and maintenance plan for all of the components related to the stormwater management system. So within the stormwater drainage report, we detail out an inspection schedule as well as a maintenance schedule for each one of the best management practices, the BMPs that are proposed on site. In this case, it's a fairly typical system for this type of development, where you have deep sump hooded catch basins that collect the runoff right off the parking lot. There's a hood on the outlet to catch floatables and be that initial point of water quality treatment. Then that gets routed through a proprietary sedimentation device, just a fancy way of saying a concrete structure with some sort of insert in it that most of them swirl the water around to further remove suspended solids, and again, any floatables, and that has a certain volume that it can hold. And then that discharges to the subsurface infiltration system, which is then further another line of treatment, technically, before the water gets down to, say, in contact with the groundwater. So each one of those items has a specific inspection and maintenance section, inspection schedule that's detailed out in the stormwater drainage report.
And who would be responsible for doing that?
That would be, the onus is on the owner to maintain the stormwater management system. Typical to any new development that gets permitted, it's typically the owner that it falls on.
Is that sort of standard operating procedure for projects of this type by Colito or Dollar General? I mean, who?
Yes. Yep. Yeah, so, this is one, site development that obviously has to meet the stormwater standards for the Massachusetts Stormwater Handbook. But any new site development that you see getting constructed has to go through the same review and design process, whether it's, I'm seeing it more with single-family homes even these days, and now all the way up to, big industrial, 500,000 square foot industrial warehouse buildings and such. They all go, they're just larger, but they're the same process, and they all have inspection and maintenance schedules.
Are those inspections filed reports with someone? Through the state or the town, or how does that work?
Typically, that's it's held by the owner, and unless there's some sort of mechanism through the town bylaw or some sort of mechanism to keep track of that. There's not a state level overview of the maintenance schedule.
I'm sort of focused on this because not only are there the cliffside wells, there's a town well that's farther up the mountain.
Yep.
But, you know, that's in the area, and I suspect that a lot of places, or a lot of operations, take maintenance for granted, and, you know, maintenance tends to be forgotten or not done, and, you know, only if, oh my God, we got a problem, you know, some car, you know, dumped, you know, a ton of gas, you know, their tank let go.
Sure.
And, you know, how diligent are they? I mean, like, I think Jim was asking about reports or what.
Yeah. Yeah, like I said, there has to be some sort of enforcement mechanism that forces the owners, not only of this property, but of any property in town, to maintain their stormwater management system. And just, I know the wells in the interim wellhead protection area, it comes up. There is a standard that increases the water quality design when you're within a feature like that. So, you know, if it's the water quality is calculated at the, you know, the half-inch rainfall, then it gets bumped up to the 1-inch rainfall. So it's a more robust water quality treatment system for being inside of one of those critical areas.
Look, you had mentioned that, you made a comment, I think, about, you know, this is a little bit over-designed, or
Slightly, not seriously, but it is a robust design. They did not go by the skin of their teeth.
I just have one more question for everybody. To the left of the building, I think it's labeled the surface infiltration basin. If I can see my map really.
Yeah.
The proposed property line is directly next to that. Is that a concern at all of having that so close to that?
I think there's a rule of thumb that you'd like to see 10 feet separation between the surface of an infiltration basin and a property line. I don't know that it is a rule or requirement. It's not like a septic system. So especially when it's just roof water, it's really just straight rainwater that goes there. So it's not a pollution source. You might not want to put a new foundation right next to it and lower and make a stone foundation, but it's very, very normal.
Okay, thank you.
I think that's, you know, mentioning the proposed property line. The property line you're talking about is actually a proposed property line.
Yeah.
This parcel actually goes out quite far, quite a bit farther off into the text there. And there is another parcel that was cleaved off of it. And I think there's between, if they actually do submit an A&R after all this is done to move the property line, I think there's actually room on the rest of this parcel for 2 other developments to go on. And, you know, so I think it is, I think, you know, the board's concern about what's going to happen with the rest of the parcel is you know, is warranted. And that's why I think we're taking a real hard look at this in terms of, you know, water quality and making sure that other developments there, they could actually, those two sites could actually house smaller retail uses of less than 5,000 square feet that I believe are allowed, that don't even require a special permit. This particular project required a special permit because it's between 5 and 10,000 square feet. So,
Would those two other lots be closer to the wells, or?
one of them would be, actually, this WPA, or whatever you were talking about, that zone would intersect the one that's furthest north. The one in the middle, the new, that other lot would be close to it, but I don't think it would actually hit it. I don't know. We weren't looking at that, but it would certainly, that parcel 100 that we've been talking about, that zone does definitely hit that parcel. I'm not sure if Ellie or Jen, do you have any comments or questions?
Sure. My name's Jennifer Uncles. I'm on the Conservation Commission. I apologize for being late. So if you covered this already, just say covered, and I'll go on to the next thing I want to say. We did have a Conservation Commission meeting last night, but we didn't formalize an official response from the whole board. So this is mostly me, but summarizing what we talked about at the meeting last night. Two things that rise up for me and the conservation concerns is, sure, I didn't know if the fact of when the test pits were done, if the drought conditions were addressed for that, and the practical knowledge that we all have of high groundwater in town and some other models that show that fluctuation, and how if you're in a severe drought that might impact those test pits. I understand it's sort of a sandy, silty, loam soil there. A state-of-the-art system sitting in groundwater isn't going to do the job it needs to do. So I don't know if that was, I know it wasn't fully referenced in the peer review.
We did talk about that indirectly, about, we said there are, some soils that show some sort of,
I can.
yeah, why don't you go over that again for?
Yep. So the test pits that were done were performed by a licensed soil evaluator, and I'm a licensed soil surveyor. So what we're looking at in the test pit, we look at the soil profile, and within that profile, we're looking for what we call redoxamorphic features, and that's essentially where if there's groundwater, when it rises and recedes, it leaves sort of a stain line, an iron rust line in the soil that you can see on the profile of the hole. So we're not looking for water itself necessarily. We're just looking for those redoxamorphic features that show evidence of where the groundwater reaches.
I understand that, and I also understand that those features don't come into play or show up unless there's water for an extended period of time. And we have groundwater that goes up and down. It might be for a week. And this building would be in trouble if it was for a week and the system's not working and you get some rain in that same week. So how do you address that when there's a drought where there's like 8 months of no precipitation and you're not going to see some of those features in the soil?
Well, on this site, and just particular to this project, we're way above the required minimum separation to those redox features that we had. Essentially, because Amherst Road, and then it dips down and then it comes back up, we're essentially making that flat, and we're closer to the surface than we are to the existing ground. So if anything, we're sort of building up and going to be in above the existing ground. So any features that of fluctuating water just wouldn't play into the bottom of the system.
If I could ask, I'm Ellie Kurth. Could you also get into how you, like, where the redox features show up in your field reports?
Yes, so there's a state form, it's called Form 11.
Yeah.
And Form 11 is typically, you would see it associated with a septic design. It's part of the soil evaluator's license comes through the Title V process for for leach fields and septic systems. So there's the Form 11, and then there's a whole chart that gets filled out, and you have to profile or list out the different horizons that you see. Then there's a column there that calls out redoxamorphic features, and if there is some present, they will specify at what depth those were identified or located at. So if there is none, there's a line up top, and it's essentially a checkbox that says, was groundwater observed, yes or no? If it's yes, then you have to mark where, you have to fill in, where the weeping is, where the standing water was, and then farther down in the chart below it, I can see you looking at it, that chart below would call out where the redox
Okay.
features are
So
identified.
Like where this NYR
Redoxamorphic features, that's what we're looking for. So they found about 120 inches, and these
Okay.
are the colors relative to that, 72 inches, 108 inches.
Gotcha, okay.
I can help us with this. For Ellie's and Jen's benefit, could you please again state what is the minimum separation between the bottom of your filtration system and groundwater, or whatever the criteria is?
Yep.
And what are we looking at this site?
Yep. So the Mass DEP standards, the Massachusetts handbook, has a minimum requirement of 2 feet of separation from the bottom of your system to estimated seasonal high groundwater. So those redox features, not necessarily water that you found when you did the test pit. So 2 feet is what's required per the handbook. We're at about 7 feet of separation. So we're well above the groundwater there.
And,
With all the fill you're bringing in or without?
Yes, so the system itself, if you think about it in a cross-section, the groundwater's here, you have a 2-foot required separation, we're gonna be 7 feet from that groundwater.
After you bring in?
From finished grade, yeah, so, relative to finished grade, yeah.
What's it now? How many feet of fill are you bringing
Well,
in?
I mean, that's,
The site will vary, so it's going to be.
Yeah, so the site will vary, so just take, for example, right in front of the store, in front of the proposed building, 174, the existing contour, I mean, it slopes down, but like just at this point, it's 170, so 4 feet right there at that point, but it changes because the topography is sort of, changes.
and the peer reviewer, or Bucky, agrees with their assessment about those distances, Jen and Ellie. So,
Yeah, it's just the concern is that the features you're referencing as that line might not be present in the intermittent rising and falling of.
If I could speak to that a little
Yeah.
bit. If I recall from the test pits, because I looked at the redox because that's what we need to look at. I don't think water was actually encountered in any of those holes. And it's almost never the case where you would have water higher than the redoxamorphic features. The redox levels are soil features that take, at a minimum, decades, but usually centuries or millennia to develop. So we're not looking at this year's drought. We're looking at what has the water been at its highest in the last 100 or 1,000 or 5,000 years. That's what those lines tell us. So we use those for design, because they're kind of the worst case scenario for the last centuries of time. And yes, groundwater certainly goes up and down, but if the redox is found here in your hole, generally groundwater is moving up and down well below that. It would have to be a glacial level event to get to that level and exceed it. So it almost never, ever, ever happens in, not just my lifetime, but civilization. As far as since we've been here as humans, those numbers really just stay right there.
No, I had a different topic. Bucky, do you have concerns? Like, I appreciate what you said about the IWPA, but is there any concern about the fact that there's actually 3 wells that are nested together, and we don't know how they operate? They might alternate, but they might pump at the same time, and so like they're overlapping radii.
I gotta say
I mean,
that,
obviously we don't know, but
I mean, as an IWPA, you know, there is no extremely well-defined Zone 2 affiliated with it. That's why we
Yeah.
have it, and that's normal because it is tens of thousands of dollars, maybe 6 figures to define one of those things. And, you know, sometimes they're bigger, sometimes they're smaller. I can't really make any kind of assessment about the wells, and 3 of them being relatively close together. I'm going to just push the I believe button that the DEP has done their job in establishing a safe radius around that. And I do know that, you know, DEP allowed an entire residential development to surround those wells effectively. And that's roof and parking lot, which is effectively the same use here. If at the proposed site, we were talking about storage of all sorts of materials that could raise some serious flags, and I would have some very serious concerns. I'd want more information. But it's, you know, household level, you know, hazardous use at this point, like cleaning for windows.
well, and road salt.
And road salt, and there's an awful lot of road salt that's being applied much closer to the wells within, you know, by the very people who own those wells. They're applying salt. The road's applying salt. I mean, it has a lot of parking lot within that IWPA, salt all over the place. And this project's even further away. So it does, salt in and of itself doesn't pose a particularly high risk at this distance.
Did you say it does or doesn't?
Does not, no. We'd be in real trouble in New England if that were the case.
Well, I think we are,
We are.
but that's
We
a whole nother
do.
meeting, I
We do have more,
guess.
our surface water certainly
I've
has
worked on
taken a
wells that
serious
have gotten
hit.
ruined from road salt, so
I
this is
have
a
no
sensitive
doubt that
issue.
does occur.
Yeah.
Mhm.
I was sort of related to that, just wondering about the bedrock that's under those wells and the efficiency of the system that's sending the water down efficiently, where it's not causing problems on the surface, but then is it, you know, because of the layout of where the wells are placed with more of a bedrock subsurface, is it easier to suck it all up and you get more problems or not?
That's where you need a $50,000 study.
Yeah, because it's bedrock, so.
Yeah,
that makes sense.
you would have to drill, I would imagine, dozens of exploratory wells through the region, and then do some pretty advanced modeling that's well beyond, you know, I think anybody's capability. And actually, maybe not the hydrologist here, but I know I am not qualified to talk about how water moves through soil over thousands of feet of distance.
Any other questions or callers?
You may have some on that.
Oh,
I don't know if you'll.
Oh, yeah.
oh. Yeah.
Go ahead.
Hi, Dan.
You talked about changing the grade of the entire lot, and I can't see where your drains are located on the backside, but you indicated that all of the runoff is going to be away from the road. Is that going to impact the apartments behind? Because the way you indicated that how you were draining the pitch of the lot after you fill it, you were indicating that everything was pitched away from the road towards the back property line. Is that going to affect the neighbor?
So the neighbor has the parking lot essentially directly adjacent to the property line that has a drainage system. But essentially, it would it's at the existing grade along the property line, so it's not getting pitched off-site towards the neighbor.
That isn't what you said before. You indicated that everything was pitched away from the road, and you showed it going towards the back property line.
No,
So
everything,
if it's going towards the back property line, is any of the surface water from this lot going to affect the drainage on the lot behind it?
I guess the short answer to that question is no. The water within the impervious area, within the parking area, the water that needs to get treated is all being collected within the parking lot through the catch basins that are being proposed.
What about the rest of the grade? 'Cause it doesn't always, in the wintertime, you get a rainstorm, it's gonna run off the top of the ground. It's not
Yep.
gonna
Yeah,
soak
so,
into the ground if the ground is frozen.
yeah, so generally, the topography of the area is that it grades from, what is that, east to west, if north is kind of running across the page this way, so it's running from east to west, down to the corner of the parcel that's off the sheet here. So generally, that will stay the same. All those grades adjacent to the proposed development are going to stay the same, so water will continue to flow where it currently flows to.
Okay, I'm just concerned about affecting the property behind it if surface water ends up running in their direction instead of into your drainage system.
No, it's a curb and gutter parking area, so it'll all be directed towards that entrance.
Thank you.
I don't know, does the applicant want to emphasize or, add anything to, your comments on the peer review and the changes that you made?
So just generally, like I had said previously, it's very thorough peer review. We went through and addressed all the comments individually, prepared the response letter. So we understand, there's going to be some time to say, check all the boxes, and if there's any outstanding items, before we come back to the board, we'll make sure that everything has been closed out, so. That's it.
And, Bucky, your view is that, they pretty much addressed all your issues, which there weren't any really major issues, and
So all the technical issues, absolutely. I do know that there are some bylaw questions about driveway offsets, for example, and some things that need to go to the planning board.
that was kind of not meant to be part of the peer review. It's a subject that it's in dispute, and actually some of it's in litigation, so I probably shouldn't say any more. We'll get that. So, I'd like the focus of this to be more on stormwater and drainage things. I know how you got into that, because I believe I referenced that the stormwater drainage report that from August was too big to mail to you. So I directed you to the town, we have it on our zoning website. And so a lot of those other documents that you ended up capturing, I can see why you kind of looked at them, but they're not really relevant to the stormwater issue. So, for those issues, those are still in play for another session.
Is there another copy of that response letter?
I can forward it to you, or you can have
I think this one.
I can send one to you and to Ellie. We have it electronic.
Okay.
So I think, thank you, Bucky, for your work here and your report. And thank you for reporting to the board and at least clearing up some questions on my part and others. You know, this property, this project is kind of, it's complicated because it's also in the watershed district, and it requires a special permit from the planning board. So a lot of the things that you brought up and discussed will be pertinent to them when they get into their permit. So I think that's, as far as the zoning board, I think you're more than satisfied what we were looking for to clear up questions for people who are not familiar with this kind of stuff. So thank you. Moving on, okay. What I'd like to do is talk with the board to discuss where they are, or where the board is in terms of where we are with the status and the progress of this whole hearing process to date. As the chairman, I have a lot more knowledge of some of these things, and the board members have, they only get to hear what happens at hearings and stuff. Look at where we want to go from here. I don't think we're at a state where we can turn around and have discussions about whether to grant or deny a special permit, or that kind of thing. I think there's a few outstanding issues in my mind, but I wanted to find out how you feel about. Are there some things that I haven't, I've missed or overlooked, and my speaking board members may have something to say?
I would ask the chairman, do the board members feel we've covered traffic flow and safety thoroughly enough?
That is something, I know I fielded some questions among the board about that. I think, that may be something we may want to take a better look at. And actually, one of the outgrowths of this is that the applicant has made some changes or modified their traffic and say their traffic study. So that may be something that I may want to, that maybe the board would want to revisit. Indirectly, there was mention of the whole driveway bylaw and the offset distances, and as you may know, there's some litigation ongoing on that, and maybe I could ask Mike D'Ortenzio to give a general overview where we are, because there's that was an issue that the board had great interest in, and sort of got superseded by some other action. So I'll let you describe it to the board and where we are and what we should do about it.
Great. Well, happy to, and good evening, members of the board, members of the public. Michael D'Ortenzio from Town Council, KP Law. It's always a pleasure to be here, so thanks for having me. So what I wanted to do tonight was to bring everyone up to speed on the court case, where it is. What I'll be sharing is the public information that's available on the public docket. There'll be a further discussion at the beginning of February with the Select Board, and of course, at the Select Board's pleasure, perhaps board members might be willing to come as well, though I don't want to speak for the Select Board on that. And in executive session in early February, we'll have a chance to talk about some of the case strategy and the next steps. So that we won't be talking about tonight, but I did want to bring everybody up to date on where we are right now. The way the state statute works and the statute that the applicant is filed under basically allows these two processes to be happening at the same time, right? On one track, you have the permitting process, the special permit here before the Zoning Board of Appeals. On another track, you have a set of legal questions that have been presented to a judge. Those are going to be going down different tracks. You know, who knows exactly what one will finish when, but they go down concurrently. And so the applicant had initially filed a complaint on October 9th of last year. And a complaint is basically the basis for the case, right? It's the applicant saying, this is my belief of what the law is. This is what I believe the town is doing wrong, and this is what I'm asking the court to do about it. The complaint is just the start of a case, right? You go through pretrial motions, and then a trial, and then in land court, a judge issues a decision. All of that can take many months. So oftentimes you'll see, and as the plaintiff has elected to do here, you'll file a motion for summary judgment. And what that means is you're saying to the judge, hey, you know, really, this is a simple case, right? Or it may not be simple, but it's not in dispute. The law says this, and here are the facts, and when you apply this law to these facts, you get the outcome that I have requested, right? And that's called a motion for summary judgment, and somebody who has filed a court case can bring that to a judge and say, let's skip the expense of all the trial and skip right to the ending. So on October 29th of last year, the applicant filed a motion for summary judgment. That kicked into gear the response from the town side. We filed both an answer, which is just sort of a technical thing so that we don't default, and then substantively, our response, our opposition to the plaintiff's motion for summary judgment. That was filed on December 12th of last year. This is a good place to pause for any questions. So again, in summary, the applicant started the case. The applicant asked for the judge to resolve the case without a trial. We then filed our opposition on December 12th. Okay, so then after reviewing our opposition, on December 19th, the applicant withdrew their motion for summary judgment. So it is no longer before the judge. It has been taken away, and it is no longer active. And then the applicant has moved to amend its complaint. And what that means is after getting our opposition for their motion for summary judgment, the applicant has decided to change tacks a little bit in the arguments that they're making before the judge. And so we have an initial hearing before a land court judge next week. And at that time, though I don't want to speak for the applicant, I presume the applicant will be asking the court to allow the complaint to be amended, which we don't plan to oppose. And then at that point, the town will have a chance to respond to the new set of facts that the applicant has presented, which is different from the original claims that were made in October. So that's where the court case stands. Obviously, our hearing before the judge next week will be our initial indication of really just even introducing ourselves to the court, right? That's our first opportunity to do that. And then we'll be speaking in executive session with the select board and any members of the board that the select board will invite. And then we'll be working on our response. Now, some of our response may be similar, right? The fundamental facts here have not changed. So some of the response may reincorporate what our initial response had. But where the applicant has introduced new legal concepts and new claims, we will have to run those down, do some work on those, and then put that response in writing, both for the board and town officials, and of course for the court. So that's where that stands right now, and I'm happy to take questions. If I don't answer them, I'll just say at the outset, please don't be offended. I'd be happy to talk to you, and we'll find a time in executive session to do it. But I'll try to answer every question I can.
Since he's modified his complaint, can he go for a new summary judgment?
Yes, and I don't want to speak for Mr. Pill, but assuming the modified complaint is accepted, then he would have an opportunity under the court's rules to go through the summary judgment process. We would have an opportunity to oppose that and to say that there are facts in dispute and this should move forward to a trial. Or, which we actually requested the first time around, that summary judgment should actually be granted in our favor. So that's what we did the first time around. We'll have to go through the new arguments and determine whether we'll do that again. Other questions?
If I could ask, I
Please.
mean, if this is out of bounds, whack me.
I've got the swatter.
Yeah, exactly. That's why I have Jim in between. If the judge accepts the modifications or amendments to the summary judgment, what sort of time frame do we have to provide an answer?
So that great question. So we will provide an answer within 20 days, which is the court standard rule. I should say the answer is very technical. It's just a kind of form that says admitted, denied, admitted, denied, admitted, except we disagree with this, right? It's sort of formulaic. And again, I don't want to speak for Attorney Pill. I presume Attorney Pill may choose to renew his motion for summary judgment. And if and when he does that, then there'll be a time period when we'll have to respond again. What date that is will depend on if and when the motion is renewed and any guidance from the judge. I would say I presume the judge will accept the amended complaint. I don't want to speak for the judge, but I presume that will happen next week. I think what we're really looking for in that initial conference is, does the judge share anything, right? These are sort of informal initial conferences. They're designed for judges to be able to ask questions and sometimes give a little bit of a sense of where they see the judge sees the case going. So I think that'll be helpful for both parties. But if and when that motion for summary judgment is renewed, that'll start a clock within which we have to respond.
I had a question about, the timelines happening at the same time. It feels like one could affect the other. So how does that work?
It's a great question. And so the statute that the applicant has brought suit under, which is Chapter 240, Section 14A, it allows a lawsuit to be filed, and I'll quote from the statute here, even if there are no plans or drawings for any buildings, right? So what this statute, it's sort of an all-purpose statute that even if you don't have an application pending, the concept being you want to hire somebody to design a building, but there's a law preventing you from doing it, and you don't want to pay somebody to do that if this law stands in your way. So you want a judge to tell you before you pay somebody to design a building for you if this law is good. That is sort of, I think, the concept behind this statute. But the statute absolutely applies in this circumstance too. Even where there are already plans on the table, the applicant has a right under Section 14A to file for relief prior to this board making a decision, the planning board making a decision at any time. So because those are operating concurrently, here we are governed exclusively by the Zoning Act. And the Zoning Act in Chapter 48, Section 9, relative to special permits, has a requirement that when the public hearing closes, we have to file a decision within 90 days. And so depending on when that happens, what the status of the court case or anything else is, right? I don't want to close any conversation that you have in terms of the traffic or anything else. But basically, we'll have to make an assessment on when this would wrap up on its own normal timeline where the board is. And that's a bridge we can cross if and when we close the public hearing, and then we have the 90 days to issue the decision. But it may very well be that a decision is needed prior to the close of the litigation to getting a decision from the judge, or it may not be. Sometimes judges issue decisions quickly, new things come up, right, as questions and public hearings continue. So it's hard for me to say exactly what will happen other than we are going to be governed by the zoning act exclusively here.
I wanted to ask, is the difference between the original filing and the amended, is it something significant? Or what are the deltas between those?
I would say there are some material differences, and some of the differences relate to further research that we did, right? So, when the complaint was filed, we, and I say we, I really give credit to Steve and Wendy, who were digging around in the dust, finding all the old paperwork. And so we were really trying to chart out the history of this zoning separation bylaw and continue to look at that. And so some of what the amended complaint is in response to details that we discovered. And then when we discovered new information, the applicant went and discovered new information. And they put that new information in the amended complaint. So for example, there's a reference to a new approval not required plan that is from 1969, right? There's a photo of it in the amended complaint, right? So that's a new fact that's responding to some new facts that we brought to the table. There are also some claims that I don't know that they're new necessarily, but I would say they're enhanced just in terms of the amount of detail that they take up in the complaint around access to a state highway and legal rights that the applicant believes exists around the ability to connect a property to a state highway with a driveway, and what power the town has to regulate that. That was really in the original complaint, but in the amended complaint it has significant more detail to it. What's no longer there was a detail about takings. So you may recall in the original complaint there was some information about the property had a certain land value estimated of a few $100,000, that the town would be liable for a taking, etc. Much, if not all, of that detail has been removed from the amended complaint, such that we're really focused on two issues in the amended complaint. One being, does the driveway separation requirement bylaw apply with this new 1969 approval not required subdivision plan that the applicant has provided? And two, because it's a state highway and under the applicant's interpretation of rules that relate to connecting to state highways, if you're in a butter, can the town enforce the driveway separation requirements even if those requirements apply to this parcel? So in some ways, those two questions are the same as the memo, right, from many months ago. But the facts that we are using to answer them have now changed, and that is what has brought the amended complaint to bear. Still the fundamentals, but instead of using the 1994, was it, approval not required, we're now looking at a 1969 approval not required.
Actually, the 2014.
2014.
But the 1994 had to do with the deeds and the purchase of the property.
92, yes.
94.
I wanted, 94. So we're moving back in time, I should say. But those are the new facts. And so now we're going to continue to do some further research in the town archives in terms of when the driveway separation requirements came into the bylaw. That's sort of a fundamental question, a fundamental fact for that first question. But what we have to do is apply the new facts that are in the new complaint or amended complaint to the same two questions that we've had.
Sure.
I have to frame my question about that last part, but going back to Amanda's question, but answering it in the inverse timeline. If the board reaches its decision first, does the judge take that into account?
So it's a great question. The judge is not going to automatically know that the board reached a decision, right? So if we reach a decision, we file it with the town clerk. Either there's an appeal period, right? In which case, the applicant could seek to either further amend the complaint or file something with the judge, putting them on notice that this has happened, right? The applicant could seek to amend the complaint again to add a 4817 claim, right? So there's so many different avenues that could go. I don't know exactly how it would unfold, other than to say that a document filed with the town clerk is presumed to be public when it's a draft zoning decision. And so generally, judges can take judicial notice of public records. But how and whether that would happen, whether the applicant or the town would seek to bring that to the judge's attention, I can't say. But what I can say is the board has to comply with the timeline and deadlines of the zoning act. So your obligations, even though the court case I find very interesting, your obligations are at this point totally unrelated to the court case. The court case doesn't factor into your thinking until the judge issues a decision. And that may not happen before you have to make a decision, in which case you'll have to make a decision without the benefit of...
Or want to.
Well, fair, yes. And whether you want to is ultimately guided by the timelines in Section 9 of the Zoning Act in terms of when the public hearing closes, you have 90 days to issue and file a decision.
My other question was, going back to what you were just previously speaking about your response and your arguments, the process in front of the judge. Are you responding and arguing the ability of the town to respond, or are you arguing the rightness or wrongness of your interpretation? What position is the town taking?
Yep, no, I think it's a great question, and the answer is the latter. So we're going to be arguing the rightness or the wrongness of our position in the case versus the applicant's position in the case.
So who set our position?
So our position is ultimately guided, our position is that and I don't want to speak for the amended complaint because we haven't had a chance to speak with the select board, and that'll be for executive session. What I can tell you is our position in the original complaint, because that's on file with the public, with the court, and is open to the public. And our position is that the bylaw is valid and applies validly to the subject law. But we're going to have to run an analysis on the amended complaint and determine what our position will be.
Thank you.
And
Those are great questions. There are more from...
So that sort of finishes your summary of where we are right now?
Yes.
And the lay of the land. And you described the sort of parallel paths this is going on. Yep. We're on the zoning board issuing special permits path while this proceeds through court. My understanding is that potentially our path may be, we may be arriving at a decision point prior to an outcome coming out of the legal case. So, I mean, the board will have to proceed judiciously on this whole special permit process. My question is the fact that the applicant has chosen to litigate on this whole driveway separation issue, and I know it's more complex than that, but does that mean that, I mean, in the absence of this, I think the board would be dealing exactly with this issue and whether it applies, and that would have an influence on our decision. Is the fact that the applicant's doing this, is it hands-off for the zoning board? Or can we, I mean...
Yeah, no, it's a great question, Mr. Chairman. So I would say it's not hands-off. If you are in a position where you have closed the public hearing and you are ready to deliberate and issue a decision, you'll have to consider all the facts and the project's overall compliance with the terms of the Sunderland zoning bylaw. So I presume it would be an issue at that time. I don't.
You think it'd be an issue at the time we've closed the hearing and we're going to make a decision? Or I'm talking about even discussing the matter. I mean, this,
Yeah.
As you recall, this whole disagreement between, the applicability of this bylaw has its roots a long time ago, months ago. And when we were discussing it, both you as town council and the applicant were issuing memorandums of opinions. I'll say that, for the board, arguing opposite sides of the issue.
Yeah.
Yes, it applies. No, it doesn't. And the board had accepted or received that input, and we were going to proceed and debate. I don't know where the board stood, whether it applied or not. And then this action took place before we could actually do it. So when you say, if I look at my list of unchecked items that we need to do before we arrive at decision time, this would be one of those issues. And I'd want to discuss, I would recommend to the board that we have this discussion and decide and make our choice. Because I think it may be very key to, the outcome of the special permit. So that.
It's a great point, Mr. Chairman. So I'd say two things. I'd say, one, the applicant is entitled to a decision pursuant to the Zoning Act. And under the Zoning Act, the law that they have sued under is not part of the Zoning Act, right? So they are entitled to a decision pursuant to the terms of the Zoning Act. That's the obligation that the board has to provide. And in that sense, the lawsuit is sort of a fiction out of your mind, right? Everybody knows the lawsuit is happening. No one's trying to hide that, but it is not relevant to the determination of your decision. The facts underlying the lawsuit, however, can be relevant to your decision. And obviously you've been presented, as you said, Mr. Chairman, with memoranda from Attorney Pill, from myself, from Mr. Levesque and others, right? And so you will be in a position to make your own determination based on those facts as to whether this applicant is entitled to a special permit under the Sunderland zoning bylaw. What I would say is this all assumes that we get to that point, right? So, it may be that, and I don't want to speak for the applicant, I haven't spoken to the applicant about this. It may be that, this gets continued for a period of time, depending on when the filings happen in the court case, if the judge is likely to make a decision, right? If it does not get continued, and we're in a position where all the other items have been checked off, the applicant is not willing to continue, and we have to make a decision, and we consider all the facts that we have at the moment, and the board makes a decision under the Zoning Act, which is what the applicant is entitled to. So I would suggest that if we get to the point where the sole remaining item is the driveway separation requirements, it may be prudent to speak with the applicant as to whether there is appetite to continue the board's decision until such time as there is guidance from the court. If there is not, then the board will deliberate and will issue a decision in accordance with the Zoning Act, and that is what the applicant is entitled to.
So I understand that it's a fictitious thing that's happening, but can we use information that is presented in that to help us?
Yes,
with our-
absolutely. Any of the underlying facts that have become part of the record here are relevant to you being considered and can be used in your determination of whether this applicant's entitled to a special permit.
Thank you.
What I wouldn't want you to say, and this is really the main item, is I know there's litigation out there, and so I don't want to give the special permit, right? Because that's not a reason to deny a special permit. But if there are facts that are in the litigation that you say, for this reason, I don't believe X, Y, or Z, then that would be allowed.
Okay.
Good. I'm happy to answer more questions as they come up.
Okay. Thank you, Counselor. It clarifies things, at least in my mind, and hopefully in the board's minds too. So, you know, if you, as far as the board, as far as, you know, checklist of things that we need to do before we say, okay, we got all the information, we're ready to deliberate and decide on a special permit or not. I think this is one item that we need to address at a future hearing and debate and decide. I sense, and I had some questions about the traffic study and the traffic topic. So I'm thinking that maybe, I know we had an initial go at the traffic report, but I think there's enough, at least I'm feeling enough concern from the board, and and if you disagree, please let me know, that we may want to take another look at the traffic study. I don't know what else remains unchecked off. We've looked at the at the plans. I mean, the stormwater, I think I have a pretty good understanding of what's there and how it weighs in my mind on qualities of the natural environment. I'd like some any thoughts from the board? Is there another item we haven't checked off that the board thinks needs?
I just wanted to review whatever revisions. It seems like there's a lot of revisions to the, or new plans or revisions to plans, or just going over.
The revisions that were submitted in response to the...
and I think some of the plans were not complete because you all were waiting on like confirmation of the location on site and things like that. So just a final set of plans or whatever that is.
I don't know if that needs to be a topic of a special permit hearing item. The applicant has submitted new drawings and new electronic files of changes that were made in response to the peer review. And those, I got, it's just like before, I have electronic copies, which, are of some use. And he's also submitted 2 full-size sets of drawings that one of them will reside in the town clerk's office for those who have bad eyesight and need to see things in big size and not look at a tiny screen. I know one thing I saw, and I checked that in the last submission of what I'll call Rev B site plans, where the site, the building was originally sort of situated parallel to 116, and then Rev B came in, they rotated it, and they reduced the parking, so that it required a whole new drainage and system. I lost my thought. I mean, I'm talking and I lost my thought about shoot. Getting old's a bugger, I'll tell you.
At one point, you can hire a traffic peer reviewer.
I mean,
No, thank you.
I don't know if we need, I mean, this isn't, the traffic report is not as Greek to me as this was. I mean, quite frankly, I didn't understand some of these things, and you're talking about soil levels and everything else, and I was getting input from, you know, from Elliot, you know, they're talking, holy, you got the wells there, you know, I mean, this is like out of my league. I need someone to, you know, that knows what they're talking about to tell us, is, you know, is this a problem, isn't, or, you know, what, you know, this needs to be done. I don't know, I mean, I don't, I mean, does the board think they need a peer review of the traffic study? I mean, it's kind of,
I was disappointed it was one day. I don't quite see that as a study. I see it as a drive-by almost, but I think we could all analyze a traffic study.
I mean, you made some revisions to the traffic study based on comments by the stormwater peer reviewer.
Yeah.
I mean, I know that was one of the issues. I think this could be addressed by, you know, scheduling a hearing, and we're going to take a look at their, we ask you to come back with the, with Bowman or whatever, and with the revised traffic study report, and let's have that, hash that out in a public hearing. I tend to think that we don't need a peer reviewer, but I mean, if the board feels otherwise, or if like new questions arise that require it, we could consider it.
And Mr. Atlantic.
Mr. Atlantic.
I have a tendency to agree with Hollis on the one-day traffic study. I don't think that's realistic. Because depending on the day that's picked, knowing what the UMass schedule is, that could make a significant difference on the reality of what's going on that road.
Well, I think we bring that up as maybe that's our next topic as a subject of the hearing. I'll say anecdotally, I have some observations about traffic there, and I know the data says sometimes, you know, it could show that cars can stack up. I witnessed a situation where on a Saturday, and there was nothing going on at the school. I hit a traffic light, and I was backed up, and I was heading south. I got backed up in front of the Dunkin' Donuts driveway, and that's like not even a high volume thing. So I think we maybe our next hearing is to look at the traffic study, and you know, maybe if you want to take, you know, if the traffic engineer wants to maybe gather some more data or not, I don't know, but I'd like to bring that up and let the board wrestle with it, and that's one thing. Another thing is this whole driveway separation issue is another unchecked box in my mind. Are there any others?
Well, one of our criteria is potential fiscal impact, so I don't know that we've heard, or if they're applicable, you know, revenue estimates, tax revenue coming to the town. Haven't heard anything what the store intends to produce for revenue, or all the subsequent things that come from. And I don't know if that's part of the zoning board's criteria.
That's one of the criteria is potential fiscal impact.
So without knowing any
I don't know if that's
revenue,
a subject for a hearing. I mean, you know, I mean, pretty much, other than fiscal impact would be, you know, tax, you know, they get the property taxes. I mean, I don't know what else is there. I mean, how profitable they make or what their revenue is not germane to that.
Basically, property tax is what you're looking for.
Yeah.
Property taxes.
And we get the
Based
whole.
on square footage and assessment and all that.
One of the things is that typically we check off these major boxes. Then when we decide on, granting a special permit or not, we gotta take a hard look at the criteria. But that's usually an internal thing. I mean, if there's information needed to help the board deal with those criteria, or wrestle with them or evaluate them, that's one thing, but I don't see the fiscal impact being a major checkbox on its own.
Understood.
Yeah, question. Well, I guess we'll open it up for public comment, so.
You're okay with that? Okay.
I'm okay with that.
It's relevant to my name is Kevin Malangoski, 418 Russell Street, by the way. It's relative to the potential fiscal impact component, and I was just curious if the board would be agreeable to discussion from the public regarding property values of abutting properties to the general facility. There's been some studies done by Clemson University, for example, that outline some of the effects of similar types of establishments on property values in surrounding areas. I just would caution overlooking some of these other subtle elements. And I think some of that could also play into, I think it's number one, the social, economic, and community needs. I would emphasize that there's probably a good amount of input from the public on those.
And to that point, I have received a tsunami of input that I need to share with the board. There's been a lot of public documents that have been submitted to me that I have, and I think that's at the appropriate time. Yours is one of them. I know that you put in, you wrote in a note, and Will Sillen submitted a interesting observation on criteria 1 that I think merits, at least consideration by the board. But I think that's going to be a little bit later when we get closer to the decision part. But I have a lot of information that I've received with, some of it is, Dollar General bashing or whatever, and that's, that doesn't have much relevance to our decision. That's, thank you for reminding me of that, because I did want to mention that. There's still a lot to cultivate here for the board before we arrive at decision time. So, any other I guess the last agenda item is public comment. So we sort of anybody
covered that base.
We sort of, yeah. Dan has been providing a lot of public comment. Thank you, Dan.
Thank you. One more.
Oh.
Yeah. Well, you have generated a new question for me. When you might share, whether that is part of the chair's piece to share with the rest of the board what has come your way is part 1.
I have. I mean, I can probably start salting it. I mean, I don't know how to. A lot of times when we get some stuff from the public, it's done in open hearing. There it is. Deal with it. I received, I get stuff dropped in the mailbox. It's like, okay, what's the vehicle to bring it to the board so that it's admissible? I mean, Or,
It's a very good question. If there are materials that you as an individual board member, Mr. Chairman, have received that relate to this hearing, it's appropriate to share it with the board so long as we've also shared it with the applicant. That's crucial. Because ultimately, when the board renders a decision, if it's making reference to any of these either public comments or professional studies, those need to be referenced and also made publicly available so that everybody can see them.
no,
So, but how you do it could be a Dropbox, you could forward it, you could print them out, whatever works best.
no, I have a lot, I've received a lot of, I mean, there's a lot of chaff in there, but there is some wheat. I said, that's interesting, you know. Go ahead.
Yeah, I'm just a little unclear whether the zoning board does cover, you know, what does community well-being mean? Is that part of the special permitting, and is there what is the place and time and the body to discuss?
Well,
As Hollis
the exact
mentioned,
wording
you know,
of that criteria one is social, economic, or community needs. And, you know, interpreting the bylaws, interpreting the criteria is what the board does. So it's, you're asking me for what a definition is. I don't know if I can put it in a concise sentence, but you know, that's when we decide on when we look at the criteria and we decide, you know, that determination that the proposed use will not have adverse effects that overbalance the beneficial effects. You know, that's really the end judgment we got to make. And the 7 criteria all play a part of that.
So I was going to say, you know, such as consumer benefits and effects on the local economy. So as you said, taxes or effects on other retail operations. Is that a piece of what's considered and when and how?
I mean, you know, potential impact. I mean, the 7 criteria are the social, economic, community needs that are served by the proposal, traffic flow and safety, adequacy of utilities and other public services, neighborhood character and social structures, qualities of the natural environment, potential physical impact on drainage and stormwater management. It's factoring all of those, and all of those may not be like a big concern. Some of them may be small. I mean, but that's what the board does. That's why you pay the zoning board big bucks to wrestle with these issues and make a decision. So.
And Mr. Chairman, there may also be the impact on public safety and municipal services.
I don't, is that one of the 7 criteria? I mean,
That's not part of it.
adequacy of utilities and public service, other public services.
Yep. We'll compare our versions after, make sure we get the right one.
Don't confuse us.
As my grandfather used to say, don't confuse me with the facts. That's what I...
So, okay, so shall we, the next topic that we'd like to discuss with the applicant is, let's take another swap at traffic flow, or the traffic study. I mean, you already have, I mean, I've heard that from a lot of people, the fact that the study consisted of one day. Because I'll tell you, it's a hell of a lot different on a Friday than it is on a Tuesday. And I know when we looked at the data before, you could say, oh, because there's a big stack of data. And then when you talk about your summary, it says, well, the traffic rarely backs up so far, but when you look within the data, oh, there's a case where it did, there's a case where it did. So, yes, sir.
Thank you. I think that's one area where a peer reviewer might be more helpful than you've considered. Traffic engineering is a professional endeavor. There's a lot of standards, and what I don't think any of us want to see you get involved in, is the traffic engineer is sitting here saying, potentially one day is all that we require. It's like probability and statistics, right? The pollsters who are you go out and you do a sample. And yes, the adequacy of the sample, and that's certainly something you can discuss, but what is very easy to get into when one is not an expert, like I go to the doctor at my age and, well, doc, did you do this and did you do that? And the doctor says, these are the things I need to do to make a diagnosis, and those are not relevant based on my medical training and expertise. It's certainly your judgment call, and it may be that a peer reviewer would agree with you, but you see, it would level the playing field if you had an engineer who could take all of your input. And if and I'm being frank, if your engineer, your peer reviewer, like Bucky made some comments, you got 78 responses. Okay? In other words, when a PE speaks to a PE, a professional engineer to a professional engineer, by God, they snap to attention and you got it back, because they speak the same language, they have the same training and education, and I'm trying to cut to the chase and avoid, needless, and plus, we pay for it. That's another factor. You pick it, and the person, and that's why Chapter 44, Section 53G is set up the way it is, right? We pay money to you, you pick the engineer, you write the check, and that's the real world, right? When you're an expert, you know who's writing the check, you know who you're working for, and it just works that way. So I'd respectfully submit all of this for your consideration, why a traffic peer reviewer might be helpful to the whole process. And for example, I think it's fair to say, because you've come up with some interesting points, and I have seen situations, I'll spare you the details, where the lay people basically managed to persuade, you need to go back and do a sampling on this day or in this season in order to have, a better result. And if your traffic engineer says so, I think it's fair to say Bowman's going to do somewhat like Levesque's done, right? In other words, that eliminates the argument if the peer reviewer says so. And it eliminates debate.
Well, the peer review we just went through certainly did clarify a lot of things for me and made me feel much more comfortable about the whole situation, and maybe a traffic study might be, because we're just guessing what we need to ask for questions, where somebody else might see something totally differently and present it to us in a way that makes more sense to us.
Or as Engineer Sparkle did, for example, with the well, it sounds like he was able to assure you why that was not something you need to work. It's a two-edged sword with the peer reviewers. And I think that's why the legislation was enacted, particularly for towns of this size, because you don't have all, you go down to Springfield and they've got the whole staff. Just something for your consideration, and I appreciate you taking it under advisement.
Yeah.
Mr. Pill, that is the second time you've pleasantly surprised me throughout this whole proceedings.
Well,
I'll just take a compliment.
Put it while you're at it.
I have another surprise for you.
No more surprises, right?
Okay. I'll be quick. Your lawyer did excellent work, and that's why we withdrew our summary judgment. Okay? And in other words, he can't say it himself, but and the partner behind him, Amy, yeah, you have a very good legal team here, and that's why we withdrew the summary judgment and filed the
An amended one.
yeah. So I just think, and I put that in the filed court document, by the way, because I think it's important to give credit where it's due.
Well, I thank you, and okay. Mr.
Crable.
Yeah, Crable, because I'm used to dealing with Mr. Levesque. I mean, do you think that even based on the comments you got here, that does Bowman want to take a look at their traffic study and amend it? Or maybe take another go at it? Because here's what I'm thinking. I mean, to have a peer reviewer jump in now and review that, they're going to tell you what, one of the things they're going to tell you is probably is what we've already told you. So I'd rather have a improved traffic report than do a peer review.
Yeah, I would say that, Bowman is obviously a reputable company. They're stamped by a licensed traffic engineer.
Sure.
They're not, they're a pretty large outfit. So, they work off regulations and standards in their industry. So for them to produce a report that was submitted and stamped by an engineer, it says it for what it's worth. It's been reviewed and meets what's required to provide the report. I understand there's concerns or questions in regard to that report. Maybe they could come here and satisfy some of the concerns and say that maybe one day is statistically one day doesn't weigh. They would make the argument much better than
I don't think you're going to convince the board.
Right.
I mean,
But to Mr. Pill's point, having two engineers who speak the same language say, we agree, these are the facts, this is what the conclusion is. I mean, that makes a lot of sense.
Yeah.
Well,
I think if we look at how we bid out the stormwater peer review, it was stated that they would review the rebuttal, right? So if there was, you'd bid it out the same way. So if they update their traffic study, then it would also be reviewed.
So I think the way to handle this is to have the traffic study and the traffic report be the subject of our next hearing. If you decide or Bowman decides they want to go back and update it or revise it or add more data, that would be better. And then we can decide, we can see what you have, and then we can decide about having a peer reviewer.
Yeah, I think that makes a lot of sense to have them here speak specifically to the concerns of the board. And if you're still at that point not comfortable with it, then peer review would settle.
So let's plan on that. So as we look at our calendar, where would we want to continue this hearing? I think we're probably into February.
From a scheduling standpoint, I would agree. The sooner the better. 2 weeks.
So that
versus
that would assume then that you're going to run with the plan with your report as is.
At least initially, till we get your concerns. And I think that's what Emily Buck Sullivan needs, is in effect to hear from all of you folks, and then she can walk away with a checklist, because what Philippe noted, an organization the size of Bowman, she's the tip of the iceberg. Like you may recall, there was another young gentleman here, and the reason he knew so much is he was part of the team. My understanding, and dive in here, is that they put a team to work, and then there's a senior executive level person who has to review and approve it, and Emily is like the point person. And so, in other words, I think the way they work, she'd have to come, and that's why it would be, a couple weeks would be great, and get all of your concerns, and then take those back and see what maybe you can persuade them. But at least then they'll respond, and if they revise it based on all your concerns, okay. If they say, no, here's the reason why we don't think we need to, we'll just keep the process going that way.
I'm amenable. Stuart?
I'll be amenable because I see everyone nodding their heads, but Emily's been here 2 meetings already. Is the thought that we haven't expressed all our concerns?
I came away from that. I mean, we brought up the whole point about, the 1 day.
Right,
thing,
and she gave her response.
Right.
Which is what our lady expressed just moments ago. So why is she going to change her response?
Well, I just hear, I mean, the traffic flow and safety is a big issue. I think it's a big issue for the board. And we're not, our anecdotal life experiences don't jive up with the conclusions made in the traffic study. And I think we pointed out some areas that we thought it was weak. I had a tough time with, I found my biggest input that I wanted to get from the traffic flow study or the traffic report was what kind of traffic is going to be generated by this use? How much more traffic is going to be introduced into that stretch of highway? The answer was that they used whatever state or national standards for a variety store, and
right.
That seemed to.
The point is that answer is not going to change between now and 2 weeks from now.
That's right.
So if the board is going to ask for a peer reviewer to force that discussion along, why don't we get on with it?
I agree. I think we should move for the peer review.
Originally I didn't, but
Yeah.
I can see
It
it will settle.
seems like
some
we're gonna
issues.
meet and it's gonna be the same answer, and then we're just gonna push the can down the road, and then we're gonna get the peer review. I'd rather go with peer review.
Go do that, or, well, we have to go out and solicit quotes and, then,
Just a quick question on the peer review process. Do they look at just the existing data from the original study, or is new data acquired?
New data.
That was my question too.
I mean, I think first of all, they look at the substance of the report itself, but I think they may go out and, there's other, I mean, there is state data on traffic in and out of that, and I mean, there's other things that maybe they can go and find some new information, but,
Yeah, they would review the report that has been prepared, and under their professional experience and expertise, comment on whether that's sufficient and it meets the standards, because we all design, as engineers, we design to standards. And whether those standards are amenable to, the board, there are standards that we have to design and meet too. So that's where the peer review would say, no, you're lacking in this, in this area, or no, it meets the standards.
And it sounds like what you're referring to, and dive in if I haven't got this right, it's the ITE, the Institute of Transportation Engineers manual. I think it's in the 12th edition now, and they have their categories, and I think that's what Emily and the Bowman team would have used. And forthright with you, I've got one case, it's in the land court now, where the opponent's traffic engineer and the applicant's traffic engineer disagreed about which category, and as you might expect, the opponent's traffic engineer, the category he thought would apply was about double the traffic numbers of the applicant's traffic engineer. But you see, what I'm trying to lay out here is the framework within which the traffic engineers work. And I can tell you, you know, because in that case I represent the opponents, we beat the, I have not figured out a way how to beat the ITE categories. They have too broad a foundation, you know, too many, there's too many samples, and they've been doing it for too many years, and they're now in the 12th edition. I have not figured out a way. If they've got the right category, then those are pretty much the numbers for that type of use. But a traffic engineer might differ, and there's also some of the specifics that you've raised about, was the university in session, was the university not in session, and some of the anecdotal stuff. And now I've got to shut up because I'm at the limit of what I understand about this stuff.
Well, that's my concern, is that if you're only looking at one day's worth of data, and I get that you're working with standards, and anecdotally, nothing in my life has ever fit inside the box of what the standards fit into. And if you're looking at the traffic on that street, 1 day difference makes a huge difference in the traffic flow. And if the standard says you only have to take a 1 day sample and a peer review doesn't collect new data, then are you really going to get a realistic view of what's happening on that road?
The peer reviewer would tell Bowman to go back and get more data.
Yeah, you report back to the board, and
You're right. Thank you. The peer reviewer would report to you, and you would say, based on the peer reviewer, back to the drawing board, Bowman.
so,
Thank you.
yeah.
And thank you, Mr. Lang.
Can we also submit, I guess, comments or questions to the peer reviewer to discuss some of our concerns?
The way this works, you helped me do this for the stormwater. You know, it's not really a request for quote. It's a little bit different. Yeah, I mean, we would be described what, you know, the scope of the work is to do a peer review of the traffic review. You know, focus. You know, we could tell them to focus on, you know, concerns that the board already has.
So they can help direct you.
And, you know, plus whatever his expertise says, you know, he may find something that, the board has overlooked. It's going to be a challenge because the town administrator that I was relying on is out on extended medical leave, so for me to execute this is going to be a challenge to turn around and, you know, solicit quotes and get proposals and have the board, you know.
You can do it.
Doesn't make it easy for you know, scheduling the next hearing and what that topic should be. Or do we just, while that's ongoing, jump right into the driveway separation conundrum?
In the board, Mr. Chairman, if I may, at the next meeting, if there is a proposal that has been drafted, the board could review that, offer comments, and then you could put that on the street.
You're talking about the request for?
In terms of a peer review.
Oh, right.
And I'm throwing out a possibility that you might want to discuss with your lawyer. One thing I've seen boards do in similar situations is, in effect, say, let the court decide, right? I mean, let the court decide because they've already got the driveway separation issue. And if, for example, you decide to deny a special permit, how you do that is up to you. If you decide you would grant a special permit, one thing you could do is make a condition of the permit that the driveway separation issue, has to be resolved. And if the court holds that it's valid or valid as applied, then there has to be compliance. I mean, I'm just brainstorming, throwing stuff out.
Let me brainstorm back to you.
Okay.
When we get to the end of our checklist, and we haven't dealt with the separation issue, would you be amenable to allowing us to leave this hearing open until we get a result from the court?
What I can do now is put some cards on the table and tell you what we're doing and what I think, and I'm happy to do that. I mean, I've always felt like trial by ambush and hide the ball really doesn't accomplish anything. And for what we've hired a traffic engineer, a second traffic engineer, who is also both a practicing traffic engineer and an expert witness. And we are asking him to take a look at what is the basis for the numbers. And when you all dig into the history, Attorney Dertenso, okay, with a name like Pill, I really try to be careful. For example, where did those numbers come from? We cannot figure out what possible basis there is in any traffic engineering standards for those driveway separation numbers. And that, by the way, it's easy to laugh when somebody says arbitrary and capricious, no relation to the public safety, because that's a tough standard you have to meet to invalidate a zoning bylaw on its face. But our thinking is, if there is nothing at all behind those driveway separation numbers, then by God, the whole thing may go out the window as arbitrary and capricious. And that goes back to traffic engineering being essentially a professional endeavor. Then another issue is, and that would be invalid for everybody, it's out of the bylaw, forget it, you never can use it again. The next issue down is as applied, and that has two parts. On the highway, that's why we put, that's under Mass DOT, not, curb cut procedures, not for you folks. Also, the Commonwealth owns the highway, local zoning cannot control state-owned land. UMass can put anything wherever they want to in Amherst, regardless of zoning. And in other words, and we've got two bases there, okay? The Commonwealth owns the land and Mass DOT. That's on the highway side. On the Clark Mountain side, our driveway entrance is directly across the street from the other entrance across the street, and that is totally consistent with sound engineering practices. And that's how we're coming at that. And then what we're also, and this is coming down, it's getting narrower and narrower, right? Invalid on its face, invalid as applied, both to the highway and to Clark Mountain, albeit for different reasons. And then the final thing is, it doesn't apply, and that's why I went back and raised the issues about, in other words, I was trying to build on their excellent historical research and say, when you go back to 1969, it really, you can't apply it here, in part because the Clark Mountain Road parcel was once a separate parcel, and under the driveway separation, that's completely cut off, no access at all, and the access isn't practical. Emily Buck did a memo on that, essentially saying, 3 feet at the curb is simply not sufficient. So we've got two reasons why it doesn't apply. One is, the history of the plans. We're trying to argue the other way on the basis of the A&R plans, and then we're also arguing, well, as applied here, we need to be able to have these two driveways, and that goes into the common law argument about an abutter's right of access
Mr.
to...
Pell, I'm sorry I asked the questions, I mean,
Well, but-
we're not here to debate,
No, I know, but what I'm trying to do, he's taking notes and I'm glad. In other words, I'm trying to put our cards on the table, because if he's going to meet with the select board in an executive session, and maybe with you all too, I think it will facilitate, number one, and I've seen other town attorneys do this. Number one, let's put facts and law on the table, see if we can settle it. Number two, if we can't, at least we know what we're fighting about. And the final thing is, and this is for you to discuss, is basically, if, for example, you can reach the conclusion that for whatever reason it does not apply to these facts, then what you've just done is eliminated any attack on the validity of the bylaw. And that's something that I've done in other towns. It's, listen, folks, let's reach a resolution that, certainly with appropriate conditions, lets us through the gate, and then whatever we're forced to challenge in your bylaw, you can keep it and use it in the future. Now, and so I did not expect you to respond. Basically, and I'm glad he's still taking notes. He's obviously a very good lawyer. Essentially, what I was doing was talking to your attorney, and you folks can listen in. And as far as discussion goes, you can and should have that with him in an executive session. We're not around. Thank you for listening. And Attorney D'Ortenzo, I hope you found this helpful and informative. And if you and your partner want to discuss it further, I'm happy to do that. I think we've all seen the best lawsuit is when you can settle and not have to fight to a conclusion.
I appreciate that, Mr. Pill, and I got the notes, so thank you.
And if you have questions, or your partner does, give me a call, and probably better we exchange emails and label them as settlement negotiations. How's that? And the reason for that, and then I'll shut up. If you call it settlement, you can talk freely. Okay, thank you for listening.
Wow. That question backfired. Oh, well. Okay, so, when do we want to have our next hearing, and what do we want to discuss?
Are we moving ahead with the traffic study?
What's that?
The peer review of the traffic study?
I mean, it seems to be the consensus that independent of that, I can start the process for, finding a, traffic engineer or traffic peer reviewer and go through that process.
Do we have to take a vote on that?
What's that?
Do we have to vote on that?
Well, we don't have any proposals to vote on yet. I mean, a procedural question, do I need the board to approve the chairman trying to get a peer reviewer for a traffic?
You don't, Mr. Chairman. As long as you have the consensus of the board, you can go ahead and prepare draft work scopes and
Scope of work
and consult with folks out there and bring that back to the board.
Is it accurate that for an engineer, the town, worded that way, can just choose one?
Oh, yeah.
Sorry.
Okay.
He's our attorney.
But that's 4453G.
That's right.
And I agree with Mr. Pill. It is subject to Section 2.3 of your rules and regulations, and what 53G requires is that each board that does peer reviews have rules and regulations. So you have a 2006 version, and it has a little bit more detail, and an applicant, if they do not like the selected peer reviewer, can appeal to what is called in the rules from 2006, the Board of Selectmen. Now it's called the Select Board. right? So there's a couple of nuances there, but fundamentally, yes, you can pick the person that you believe is best to perform the review. And
Without the 2 quotes.
Oh, I'm sorry. I thought you were asking generally. So there is still a necessity to procure services under the procurement law, depending on the estimated value.
Well, but the procurement law exempts engineers.
Yes.
That's what I'm asking.
So I don't want to assume, and this is, I think you're likely going to want, for what Mr. Pill had said, a professional engineer. I don't want to assume that, not seeing the scope of work. If that is where the board lands, which I, again, think is likely, but in my job, I never want to assume, then the procurement law would exempt engineers, architects, and,
Just trying to save 2 months of that.
yes, and attorneys, so. So that would help. But you know, our general view is it's helpful to come up, even if you don't have to formally procure it, it's helpful to come up with a scope of services, have that scope of services that everybody on the ZBA is comfortable with. And then you can have a discussion as to whether there's somebody that you've identified, whether you want to put that on the street. The Inspector General would always say soliciting from at least 3 individuals, even if you're not formally publishing it, is in the town's best interest. That's generally advice we give. So you have flexibility. That's the nice thing.
I didn't think it was possible. My head's hurting more now than it was.
Sorry about that.
So,
FYI, Steve, I'm out of town until the 13th of February.
till the 13th of February.
I can meet anytime off. I'm actually coming back on the 11th, but
Well, so shall we look at the week of the 16th, the Tuesday, Wednesday, Thursday, which are the dates we kind of prefer, or the 17th, 18th, and 19th of February?
I'm okay for all of those.
Do the 17th or the 19th?
What was that?
Tuesday or Thursday? We're gonna do
Oh, so 18th's no good.
17th, no good.
19th.
19th.
And that is the,
19th.
Mr. Chairman, I'd like to say, I believe that is the school vacation week. I don't know if that's of relevance to anybody. I'm available, but
You are available?
yes.
Okay. Okay, so if everybody could confirm on their calendars that Thursday, the 19th of February, this hearing will continue until then,
7 p.m.?
7 p.m.
Did you, I'm sorry, Mr. Chairman, did you say the 17th or the
Third,
19th?
I may have misspoke.
I
Thursday,
misheard.
March 19th.
February.
I gotta get the Advil out when I get home. Okay. Thursday, February 19th at 7 o'clock.
Wait,
7 p.m.
Yeah. And at that hearing, I think the topic will probably be the driveway separation issue unless it's magically resolved beforehand. And hopefully I'll have proposals for traffic peer review for consideration. Okay?
Yep.
And are you, Mr. Chairman, just so I have my notes, are you looking to get proposals from traffic engineers or to socialize with the board what the scope of services would be?
Well,
Or you could do both.
I mean, when we did the stormwater one, I had some help from Ellie and from Amanda, and working with our town administrator to put together the scope of work and job description. So I think probably go the same. We Will you be able to help me again?
Doubling my rate.
I thought that worked very well last
Oh,
time.
Triple it.
No, why not? Triple it, tripling it.
Well, you're earning.
Go for it.
I know.
That's right.
For the record, we don't make any money. I need to state that. That's why we're doing it.
I'll submit your request to the accountant and see if he pays. Okay, I think we're done.
So, Mr. Chairman, we'll confirm in writing with the applicant probably tomorrow on that date, but it sounds like everybody's available then, so.
Yep.
I think unless there's anything further the board wants to discuss, a motion to continue.
Is there any more dead horses that people want to beat?
Would be in order.
Okay. Well, thank you very much.
Thank you.
See you Thursday the 19th.